Hello, everybody, and welcome to this very special Brennan Center live event. For those of you who don't know, the Brennan Center for Justice at NYU School of Law, we are a nonpartisan law and policy institute. We work to strengthen, to reform, and when necessary, to defend the systems of democracy and justice in this country so they work for all of us. And those issues are urgent, of course, all the time, and they are especially urgent now. I am Michael Waldman. I am the president and CEO of the Brennan Center. And before we get started and before we hear from our conversation, I want to share with you just a couple of housekeeping matters. First of all, the Brennan Center is a nonpartisan organization. We cannot support or oppose any candidate. We can and will today discuss the issues, the topics that move and motivate American politics and constitutional considerations. Civility is important in these conversations and important to all of us. Those, if it happens, who post rude or intemperate language in our message streams here or on Facebook or YouTube will be removed from the conversation, though we haven't really had to do that very much. Live closed captioning will be provided. And if you want to follow along with the conversation on social media, you can with the hashtag Brennan Center Live, all one word. Now, quickly to today's program. As those of you who follow our work and follow these Brennan Center Live events know, we care a lot about the U.S. Supreme Court, its impact on our society, the way it makes decisions, and the power it wields. That's true today, but of course, it's been true throughout so much of American history. Right now, we are focused on the hard right turn this court has taken, the political controversy surrounding the court, what can be done about it, the way it makes decisions, the embrace of originalism, and so many other things. But of course, this is not the only time in American history that the Supreme Court has been embroiled in controversy or has taken major steps and made major moves. And it's important to know the past to understand how we got to the situation we're in today. It is said history does not repeat, but it rhymes. And that is why we're so excited to be able to have a conversation today with Cliff Sloan, the author of the new book, The Court at War, FDR, His Justices, and the World They Made, which tells the story of the U.S. Supreme Court during World War II, a time when so many issues of human rights, civil rights, presidential power, and the role of the court and its politicization really came to the fore. We all understand and talk about, for example, court packing fight that FDR waged to take on the Supreme Court of the 1930s that was threatening to strike down so many New Deal laws. By the 1940s, he had appointed almost all the justices on the Supreme Court, and it really became his court. Now, I'm seeing that the screen is dark, but I'm going to assume you can still hear me. We are very glad to have Cliff here. He's a Georgetown law professor, the author of a wonderful book on Marbury versus Madison, an old friend of the Brennan Center and of mine. And I'm delighted to have the chance to turn over the mic, if not the camera, to Faiza Patel. She is senior director, co-director of our Liberty and National Security program at the Brennan Center, an expert in civil liberties and in the ways the Supreme Court and the law can deal with, among other things, religious and ethnic minorities at a time of national security panic and crisis, which certainly in the Korematsu case was something we saw in the court at war. So Faiza, please take it away.
Great. Thank you, Michael. And welcome, everybody. Very excited to be here. So before we turn to Cliff, let's just set the scene a little bit. It's the summer of 1941. And President Roosevelt has just made his 7th appointment to the Supreme Court, giving him an unprecedented influence on the court. Only George Washington appointed more justices to the Supreme Court. And the court is interesting. It's progressive on some issues. For example, on voting rights and even reproductive rights. One of the early cases on which the foundations of reproductive rights and privacy in this country is built was decided by this court. but it also bends to the will of the president on issues that are important to him. And the closeness of the relationship between several justices on the court and the president is really striking, particularly to a modern reader. And it seems at times that the separation of powers, the way we think of it now at least, really doesn't exist between the court and the president. And there are two cases during this time which are really remarkable and bear a very long legacy. The first, of course, is the Korematsu case, which Michael mentioned, which validated the internment of Japanese Americans during World War II, and a case that has been, both repudiated by the Supreme Court recently, but also served as the basis for President Trump's call for banning Muslims from the country, in part. Another important case during this time was a case in which the court approved military trials for 8 German spies who were found on US soil. And that case had important ramifications when the Supreme Court was considering cases arising out of the prison at Guantanamo. So a lot of what the court did in legal terms, and these are just 2 examples, had a lot of resonance through the years. And we're really fortunate because we have with us today Cliff Stone, who is the foremost expert on this fascinating period in the court's history. And so we are going to spend some time with him finding out about how FDR changed the nation's highest court and the consequences of that, which we are still feeling today.
Thanks very much, Faiza. It's great to be here with you, and thanks to Michael Waldman and the Brennan Center. I really appreciate the opportunity to be here today.
Great. Well, let's dig in and sort of start with the basic question. So what inspired you to write this book? What was it about, the Supreme Court during World War II that struck a chord with you?
Well, I was working as a special envoy for Guantanamo closure in 2013 and 2014. And in connection with that, I was reading the Supreme Court decisions on military detention, including the infamous Korematsu decision that has been mentioned. But I also read a decision the year before, which was the first of the deeply shameful anti-Japanese decisions called Hirabayashi, which was about a curfew targeted to Japanese American citizens. And I realized that exactly 1 week before the Hirabayashi decision, the Supreme Court had issued the famous decision striking down, at the height of World War II, a mandatory flag salute in West Virginia public schools. It was on behalf of what was then a reviled and despised religious minority, the Jehovah's Witnesses. And it really struck me that within 1 week, within 7 days, you had one of the greatest civil liberties decisions in the history of the Supreme Court and one of the worst civil liberties decisions in the history of the Supreme Court. So I got very interested in that subject of the Supreme Court during World War II as a subject, and I discovered there's very little written on it. There's a ton written on FDR's battles with the Supreme Court in the 1930s and the failed court packing plan in 1937 and the famous switch in time that saved 9, where one justice was perceived to switch his vote to uphold New Deal programs. And then there's a lot written on the Warren Court beginning in the 1950s, but there was very little written on the Supreme Court in World War II as a subject. And so I started digging into it, reading up on it, and it turns out to be quite a story.
Fascinating. I mean, one thing that's sort of interesting about this dichotomy that you identified, between the Jehovah's Witness case and then the Japanese curfew case coming a week after, is obviously the difference in context, right? The difference between the domestic context and the security context.
Yes, although, they all relate to the war. The war dominated everything for the justices. It dominated their personal lives, and it dominated all of their decisions, including the ones that did not explicitly relate to the war. And it was really a tale of two courts. It was the best of courts and the worst of courts. And again, they were both very much related to the war. And so in a decision like the one striking down the mandatory flag salute, and in other decisions as well, which you alluded to on reproductive rights and voting rights, and a whole series of decisions during World War II, the Supreme Court, in very self-conscious and explicit contrast to our enemies, to the totalitarians, to the fascists, to the Nazis, protected and recognized and expanded constitutional rights. And in doing so, they very explicitly drew this contrast. And so, for example, in the flag salute case, the flag salute had been adopted in the wake of Pearl Harbor as part of a wave of patriotic fervor. And it is a very famous case with Justice Robert Jackson famously and eloquently standing for the principle of free speech and saying, in our constitutional system, no government official can tell you what you have to think or believe. And he famously said, that is a fixed star in our constitutional constellation. But at the same time, it was very clear that a very important part of this was the contrast with our enemies in the war. Jackson explicitly drew the contrast with what he called our totalitarian enemies. And he even pointed out in the opinion that the flag salute that the children were ordered to engage in, like this, was very similar to the Nazi salute. I have a picture of it in my book. And this comes up in the other cases recognizing and expanding constitutional rights as well, such as the one on reproductive rights, where the court struck down a law from Oklahoma, which called for compulsory sterilization of habitual criminals. And it was very much a part of the dynamic of that case as it came to the Supreme Court, that everybody was very aware that Hitler and the Nazis had been engaged in this program of forced sterilization for years in the interest of racial purity and racial supremacy. And the prisoners who faced sterilization and their lawyers said that the Oklahoma law would represent the Hitlerization of American law. And in the opinion striking it down, where the court found a fundamental liberty interest for the first time in the decision about whether to have children or not, that in that decision, Justice William O. Douglas says, in evil or reckless hands, compulsory sterilization can lead to the disappearance of entire categories of people. And everybody knew who and what he was talking about. And the same thing is true in a very important voting rights decision in 1944, where the Supreme Court struck down the all-white Democratic primary in Texas and throughout the South. It was the first big victory for Thurgood Marshall in a case that he argued in the Supreme Court. But it was very much a part of the context of the case and how it was perceived at the time, that this was in the context where we were fighting an enemy whose regime was premised on racial supremacy. And there was a great deal of civil rights ferment and activity and turmoil going on in the country at that time. The African American community had embraced a campaign that they called the Double V campaign, victory over fascism abroad and racism at home. And there was a whole series of events and developments related to that. And that was also very, very much a context of the voting rights decision. And so there is this sense that as to both the best of courts and the worst of courts, such as the deeply shameful anti-Japanese decisions and the Nazi saboteur decision that you made, the war was very important to both. Now, a critical difference between the best of courts and the worst of courts is that in decisions like Korematsu and the Nazi saboteur case, the justices would have had to cross FDR and cross on a war-related issue. And on issues like reproductive rights and voting rights and protecting the civil liberties of a despised and reviled religious minority, they didn't have to cross FDR. But both of them very much related to the war.
Yeah, I mean, I guess one thing that strikes me in sort of thinking about, you're right, of course, that those decisions are in the context of the war, in the context of patriotism and sort of, the feeling of being in this enormous struggle. But like, if you think about detention, right? I mean, of course, that was something that Nazi Germany was famous for doing, of detaining people who they didn't like for whatever reason. So, so I think that goes to the core of your argument, which is that, that didn't strike the court as being like the fascist regime that we're trying to defeat in the war. And so I think that gives us a really great entree into the point that you make in your book, and which was just extraordinary for me to read about the sort of relationships and between the judges of the court and FDR, and the amount of influence and interaction they had with the White House. So maybe we can kind of jump to that. I know it's a bit out of sequence for what we had planned, but maybe we can go to that. It seems to segue nicely.
Yeah, no, absolutely. I mean, as you mentioned in the introduction, FDR had appointed 7 of the 9 justices by the summer of 1941, and he had elevated an 8th to be a chief justice. And so it was this sort of remarkable imprint on the court. But it wasn't just the number of justices that he appointed. He had very, very close relationships with almost all of them, very close personal relationships. And with many of them, he had worked very closely with them on policy issues. And after they went on the court, in many respects, and certainly to today's eyes, it was an excessively close relationship in terms of matters that the justices worked on that were sort of non-judicial policy matters. And let me give you, a few examples. In 1941, when probably the biggest and most contentious issue in the country was whether we should be engaged in preparedness for war, and there was a lot of isolationist sentiment in the country, and FDR was pushing hard for preparedness. And just about every justice during this period went out on the hustings and gave very strong speeches saying, we need to support the president and we need to support him on this very important issues. And some of these speeches by the justices on this very contested policy issue were explicitly coordinated with the White House. For example, one of the lesser known justices, Frank Murphy, who had been a mayor of Detroit, governor of Michigan, U.S. Attorney General, he was the only Catholic on the court. And there was concern in the Catholic community in the U.S. about the Soviet Union. And remember, the Nazis had invaded the Soviet Union, and the Soviet Union was now on England's side. But there was concern because of the Soviet Union's anti-religious actions. And so in coordination with the White House, Murphy went to speak to the Knights of Columbus, and he told them that by far the biggest threat right now is Nazi Germany, and we shouldn't worry about the Soviet Union. We should welcome them to England's side. And it was a very, very strong speech on that. And after the speech, FDR sent word to Murphy that he was tickled to death by this speech. But there are even more sort of startling examples when we look at them today. And I'll just give you 2 examples of that. But literally, you could go through every justice and talk about these. But one of them, another of the lesser known justices, James Burns. He had been a senator from South Carolina, was a very close legislative ally of FDR in the Senate. FDR appointed him to the court in the summer of 1941. And he actually left the court in the fall of 1942 to join FDR in the White House. FDR said, come, you'll be the assistant president. You'll be in charge of the economy. But before he left the Supreme Court, while he was still a sitting justice, after the Pearl Harbor attack, FDR put him in charge of war-related legislation for the administration. FDR told all of his cabinet heads that any war-related legislation has to go through Jimmy Burns. Burns was frequently working out of the White House. FDR named him a key intermediary between the Roosevelt administration and Congress on this very important war-related legislation. And there was a lot of it. And of course, it all could have come before the Supreme Court in terms of interpreting that legislation and evaluating it. But here you have a sitting justice working out of the White House very closely with the president and his advisors on perhaps the most important issue with Congress at the time. And the last example that I'll mention, which is remarkable, is that in 1944, while a sitting justice, William O. Douglas came very close to being FDR's running mate. FDR had decided to sack his vice president, Henry Wallace. And so the question came up, who would be his running mate? And FDR initially very strongly favored Douglas. He was very close to Douglas personally. He thought Douglas had great political potential. His humble upbringing in the Pacific Northwest, the way he carried himself in public. FDR even talked about the way Douglas's hair blew in the wind. And FDR told his advisors that he wanted Douglas to be his running mate. Well, his political advisors were very skeptical. Douglas had never run for office, and the head of the Democratic National Committee was from Missouri and was very close to Harry Truman, and they were pushing Truman. And the week of the Democratic Convention in Chicago in 1944, FDR nominally left it up to the convention to select his running mate, but he released a letter that week saying he would be happy to run with either Harry Truman or William O. Douglas. And those were the only two names on the letter. And right up until the final day of the convention, Douglas was viewed as one of the leading contenders and by many pundits as the leading contender to become vice president. Douglas himself was not in Chicago at the convention, but there were a group of people there working very hard on his behalf. So you have this spectacle of a sitting justice being, very, very active in the presidential politics of the time. And so in all these respects, I mean, you're absolutely right, Faiza, in terms of separation of powers. It was basically obliterated in terms of the way that FDR and the justices were working together on a wide range of issues. And in many ways, FDR sort of saw the justices that he had appointed just as part of his official family, as part of his team, in a way, part of his personal bullpen there that he could call on when needed.
Yeah, I mean, it really is quite shocking to modern eyes, actually, reading these descriptions and the things they did. I just want to remind everybody who's online that you can ask questions in the chat, so please feel free to do so. I want to stay with this for a minute, Cliff, this relationship between FDR and the justices, because obviously there are sort of several strands of complaint about the Supreme Court these days. One strand relates to the closeness of certain justices, including, mostly Justice Clarence Thomas, with, big donors and sort of accepting trips and gifts from them. And I think the other one, which is maybe, which also sort of springs to mind, is sort of the idea of the court as being highly politicized, which in some sense, you might say, well, given the relationships between the court in the 40s and the president, like the idea that there was no separation of powers, it strikes me as being quite similar to this idea of politicization of the court. And I'm just kind of curious as to, whether you think the way that the Roosevelt court operated had any consequences on the long term for us, and how it relates to these more modern controversies.
Yes, and I think it absolutely does. And there are two issues that you raise, and I want to talk about each. One of them is judicial ethics, and the other is politicization of the court and a sort of unseemly kind of closeness on positions with leading political actors. But in terms of ethics, and of course, with all of the sort of disclosures about different kinds of financial benefits, there's a great deal of discussion about the need for an ethics code for the justices. And I very strongly think that there should be a strong and binding ethics code for the justices, and also that there should be strong public norms about it. But I think that it is helpful to look at this period, because it wasn't just a separation of powers issue. In my view, it was an ethics issue when the justices were engaged in all these non-judicial roles and activities. Most of them not with the sort of financial character that the current issues raise, but still very much ethical issues. And one of the things that I think it shows is that it's very unfortunate that this discussion about an ethics code has become a partisan issue. This experience with the FDR justices shows we have ethical issues that come up with appointees by Democratic presidents and appointees by Republican presidents. And it should be a bipartisan issue. It should be a nonpartisan issue, that we need a strong and binding ethics code, and we need very strong public ethical norms about how the justices conduct themselves. Now, the other point that you raise about the politicization, I think, is a very, very important point, because we were talking about the differences between cases like Korematsu on the one hand and the cases recognizing constitutional rights on the other. And I think a very important lesson from Korematsu and the other anti-Japanese cases that the court decided is the judicial disaster, the catastrophe that results when justices are unwilling to stand up to the president who appointed them, or to that president's backers, or that president's political network. And that, I think that is an especially important lesson today, at a time when the votes of the justices correlate with the preferences of the political party of the president who appointed them more than at any time in our history. So I think it's an extremely important lesson from the infamous record that the court compiled in cases like Korematsu.
Yeah, I mean, I think that's certainly a lesson we can take here. So let's talk about Korematsu, because that's obviously one of the most infamous cases in the history of the Supreme Court. And when you were mentioning those two decisions within a week of each other, I was remembering that there were two decisions the Supreme Court did within maybe not a week, but a few days of each other a couple of years ago. So one was Masterpiece Theater, which was where they basically upheld the right of a cake maker to refuse to bake a wedding cake for a gay couple, on the grounds that there was some evidence of discriminatory intent in the record. And then a couple of weeks later, the case was related to the Muslim ban, where the court was like, yeah, it's okay that Trump said he really wanted to keep Muslims out of the country. They did this interagency process, so now it's all okay. So, the ban can stay in place, which sort of struck me the same kind of dichotomy in a sense, where, some interests are more important than other interests. But in that case, of course, there was the whole national security aspect to it that maybe was more explicit these days than it was, during the Roosevelt court. But I guess what I'm trying to get at with all of that is that, Korematsu has been so central for many of us who work in national security issues, particularly with respect to issues around bias, with respect to, deference to the executive branch's security judgments. It's a really important case. And so I'm wondering, maybe you can talk us through that case a little bit, and and how it came to be that the justices got to the conclusion that they did, and obviously the powerful dissents in that case as well.
Yes, absolutely. And so, and of course, Korematsu upheld the FDR's executive order and the program that was then adopted and implemented by the War Department, and in particular by a blatantly racist general on the West Coast who was overseeing it. Korematsu appropriately is viewed as one of the Supreme Court's worst decisions ever, up there with Dred Scott and Plessy versus Ferguson. But it is still to this day shocking that the Supreme Court upheld a policy that led to the incarceration and the persecution of American citizens for no reason other than where the country where their parents came from. And the justices blessed this because of what they saw as wartime needs and, as you say, the requirements of national security, because the supposed justification for it was that they could not, was that there was a threat, an internal security threat, both from legal Japanese residents who were non-citizens and from Japanese American citizens, and that they couldn't in a timely way determine who was loyal and who was not loyal. And, you know, Justice Black's majority opinion in response to the complaints says that, well, war is a series of hardships. Everybody suffers hardships in war, which is really a sort of shocking back of the hand to the incarceration and persecution that the court was blessing. And in that case, there were three very important dissents, and to the credit of those justices, Justice Robert Jackson, Justice Frank Murphy, and Justice Owen Roberts all objected to it. But even a year before, the court unanimously actually had upheld a curfew with criminal penalties that the only citizens it applied to were Japanese American citizens. And, you know, Frank Murphy had been skeptical and planned to dissent, but then he didn't want to be the only dissenter, and he wrote a very kind of critical concurrence. But once again, it was the supposed need for national security. And I think there are a couple of points that I think are especially important. And one of them is the danger of the Supreme Court's deference to the government's wildly inflated claims of national security. And even on what was before the Supreme Court, there is no way that the claims of national security justified this kind of blatant discrimination. But we see that again and again. And as you mentioned, Faiza, that comes up over and over, where there's an issue about whether the government, about whether the Supreme Court should engage in this kind of a deference anytime the government raises the claim of national security. But it also is very shameful what the executive branch did in litigating these cases in the Supreme Court, because both with regard to the anti-curfew cases and with regard to the Korematsu and related incarceration cases, the government deliberately withheld important evidence from the Supreme Court that directly undermined its claims of national security. Now, that doesn't get the Supreme Court off the hook at all, because even on the record before the court, it was a massive and historic injustice. But the government's record here in the way it litigated the case in the Supreme Court also is shocking and also should be a continuing lesson to us. And I'll give you one brief example. In this report that the racist general did, justifying his decision, he emphasized what was called shore-to-ship signaling, where supposedly there had been all these episodes on the West Coast of signaling to ships at sea. And so the justification was this is coming either from the Japanese American citizens or the lawful Japanese non-citizens. And there were a couple of young lawyers at the Justice Department who were skeptical of this, and they checked with the FBI and the Federal Communications Commission, and J. Edgar Hoover and the FCC both said, absolutely, this did not happen. We looked into it extensively. It did not happen. And in fact, the chair of the FCC said, and we told the general that before he made his decision on incarceration and before he issued that report. And those young lawyers wanted to put a footnote in the brief, basically disavowing it. And ultimately, at the War Department, John J. McCloy, who later was at the pinnacle of American law and business in the post-war world, strongly objected. He actually got the Solicitor General to stop the presses, literally stop the presses, stop the brief, and they watered down the footnotes so that it was incomprehensible. But it's really a remarkable story about the government's deception with regard to this national security issue that, again, then had this, profound human impact and toll.
So let me ask you this. I mean, this deference to national security, of course, this was in a time of war, and the punishment exacted on Japanese Americans was very extreme, detention. But do you think that the court has changed in its deference to the executive branch's judgments on national security threats? Or do you think there's been like any substantial development in that jurisprudence since Korematsu?
Well, I think that there have been, unfortunately, many instances when the Supreme Court has continued to defer to the government when it invokes national security. You were mentioning the Muslim travel ban, and that, in my view, is very clearly a case of that, of excessive deference to the government's claim of national security. And of course, in that case, in dissent, Justice Sotomayor said, what the majority is doing in upholding the travel ban is Korematsu. And then, sort of stung by that, Chief Justice Roberts, in the majority opinion, said Korematsu has nothing to do with this case. And just to be clear, Korematsu has been overruled in the court of history. And he quoted a line from Justice Jackson's dissent in Korematsu saying it has no place in the Constitution. And Justice Sotomayor in dissent said, we're glad you're disavowing Korematsu, but what you're doing is like Korematsu. Yeah. Including on excessive government deference. But the one thing I will just say briefly is that I think, to the court's credit, in the Guantanamo cases in 2004 to 2008, it rejected many of the Bush administration's claims that there could be no judicial review of habeas claims by detainees at Guantanamo. And so that actually is a rare instance where the court did reject those claims of the national security and kind of cutting off all forms of relief. Now, unfortunately, in my view, what happened after the Supreme Court decisions is that the lower courts, and the DC Circuit Court of Appeals in particular, then really sort of gutted those decisions and rendered them almost meaningless by being excessively deferential whenever cases were brought. And so it's a very unfortunate instance of the fact that these decisions, which, as I say, I think admirably rejected the Bush administration's position, then got extremely weakened, and ultimately so that they had almost no effect after the Supreme Court rulings.
Yeah, I think that's exactly right. It was very disappointing, some of the decisions that came out of the district court and the DC Circuit on individual petitions from people out of Guantanamo. But I would love to continue talking about this, but maybe we should just move on to some more sort of general topics as well. One thing that sort of struck me when reading the book, coming back to the court itself, was that the Chief Justice, right, seemed to be in a different position vis-a-vis the administration than the other justices. And I'm thinking now a little bit about the Roberts Court as well, and the extent to which one can look at a Chief Justice trying to exercise a slightly different role than the other judges on the court. And I'm wondering whether you have any thoughts on that.
So Chief Justice Harlan Fiske Stone, very, very interesting and important figure at this time. And FDR elevated him to be Chief Justice in the summer of 1941. He had been appointed to the Supreme Court in 1925 by Calvin Coolidge, his Amherst College buddy. And but he had largely been on the side of justices who were willing to uphold social and economic programs in the 1930s. But it's been well documented that the main reason that FDR elevated him to be Chief Justice is that FDR was single-mindedly focused at the time on preparing the country for war, and he wanted as bipartisan a government as possible. And so he loved the idea of appointing this Republican, this Coolidge appointee. The previous summer, FDR had done something very similar. He had named prominent Republicans to be Secretary of War and Secretary of the Navy. And Stone did not have the same kind of personal relationship with FDR. And he actually, even at one point during the war, FDR wanted him to sort of oversee rubber production while he was still the Chief Justice, because there was a shortage of it. And Stone actually, declined to do that. But at the same time, Stone was very, very supportive of FDR's war leadership. And the day after he was confirmed as Chief Justice, or shortly afterward, he participated with FDR in this national radio address on the 4th of July, where FDR kind of gave a speech about the country and the need for war preparedness. And afterwards, he had Stone lead the country on the radio in the Pledge of Allegiance, in a recitation of the Pledge of Allegiance. And I'll tell you one other anecdote that I think is revealing about Stone, which is took place on December 26, 1941, so just a few weeks after Pearl Harbor. Winston Churchill had come to Washington in this surprise dramatic visit earlier that week, and he'd been staying at the White House. And so then Churchill is addressing a joint session of Congress on December 26th. All the justices are in the front row, and he gives this rousing, eloquent, dramatic Churchillian speech. And he looks out at the audience, and then he lifts his fingers in his trademark V for Victory salute. And in the front row, very prominently, Harlan Fiske Stone lifts his fingers in a V for Victory in response. And this exchange between the Prime Minister and the Chief Justice is prominently reported in newspapers throughout the country. And the meaning and the message of it was clear. The court was in the fight.
It's quite a story, quite a few stories actually, not just one. So we have some great questions from the audience. So I'm going to kind of jump in on a couple of these to start us off. The one question is, was the court routinely involved in politics prior to World War II? So was this court different, or is it a continuation of something we saw before?
Yeah, that's a great question. And also related to it is, did it continue after the World Court? And so in my view, there's a few things to keep in mind. So first of all, I think that there were instances of justices being very involved in policy and politics. I don't think it was as pervasive and as across the board as it was with the FDR justices. And part of that was that there was this, sort of moment with this extraordinary combination of circumstances where FDR had all of these appointments at once after he'd been battling the court. But I would say a couple of things about that. First, the fact that it had been done in the past, even in more one-off instances, in my view, that doesn't make it right, for one thing. And the other thing is that, justices had different perspectives on it. I talked about Douglas coming very close to getting the vice presidential nomination. Well, there are other examples of justices running for office while they're on the Supreme Court. John Jay, the first Chief Justice and one of the authors of the Federalist Papers, actually ran for governor of New York twice while he was Chief Justice. And he lost the first time, and then he won the second time, and he resigned from being Chief Justice. And in 1880, there was one justice who very actively pursued the Democratic nomination for president while he was justice. But on the other hand, around the same time, in 1876, there was talk of the Chief Justice being a candidate for president. And he very firmly ruled that out, took himself out of the running, and said that justices should stay far from what he called the political whirlpool. And I absolutely am not a candidate and will not be one. So there were some instances, but there also was a difference of views. And then that kind of continues after FDR, where there are sort of, one-off occasions with particular justices. The most famous is LBJ with Abe Fortas in the 1960s. And when it ultimately came out, controversy over Fortas's nomination to be Chief Justice, among the controversies was that he had been advising FDR, whom he had known for decades, on a wide range of issues, including the Vietnam War. And there was a very strong public reaction against that. And so, some people sort of date the kind of current expectation that justices won't be involved in that kind of policymaking and politics to the whole sort of, Fortas experience and the way that exploded at that time.
Yeah, it's interesting. One question is sort of the public's reaction to the Supreme Court. I mean, it seems that, certainly in our time, the court is subject to minute scrutiny. Is that new? Does it have a long tradition? I mean, it seems from your book that certainly people were writing about the court and talking about the personalities on the court and their relationships with the president. But how would you rate that on sort of a spectrum? Like, has that changed? Is it more intense now? I think all media scrutiny is more intense now, probably. But aside from that.
Well, in terms of the kind of justices' relationships with FDR and some of these activities, many of which were public in terms of, I was mentioning, for example, the justices giving speeches in 1941, and those speeches were covered, and there tended not to be critical commentary of it about it. So it's actually very surprising when you read the press at the time that there is less of a reaction than there was. The full extent of it may not have been known, but I actually found one article that talked about Burns being an intermediary for the White House on the war-related legislation, and also talking about Burns spending so much time at the White House working on war legislation. Every now and then you would get some editorial comment or a columnist saying that they were all, sort of too close to FDR, too much a part of his official family. And there were a lot of reports about, Frankfurter and Douglas being with FDR a lot. So every now and then you would get a sort of mild comment. But I think there's no question that if you had those activities today, there would be far more reaction, far more disapproval, and I think appropriately so. But at the same time, you're talking, if I said just generally, about the public interest in the court, and there actually was a great deal of public interest and coverage of the court, especially with all these new justices coming on the court. It was a much younger court. It was a much more liberal court. And one of the things that some of the media pointed out was when Charles Evans Hughes, who had been Chief Justice, stepped down in 1941, for the first time in a long time, there was nobody on the court with a beard. And so as the 1941 term began, there's a big, long profile on the court, and it's headlined "Young Beardless Liberal." So there was a great deal of attention. But, the idea of the justices being liberal, I just, very briefly want to note that the expectation at that time was that all these FDR justices, and they were all close to him, and they were going to march in lockstep and be in unison. And in fact, it was anything but. Very quickly, among the FDR appointees, sort of two rival blocks and bitter divisions actually very quickly emerged.
What about in terms of the decisions of the court, as opposed to just the personalities of the justices? Were they sort of watched with the same interest?
Yes, they were. Absolutely. I mean, there was very kind of extensive coverage of the opinions when they came down, and so yeah, there was kind of tremendous attention to the court. I remember this is in the. There were a few things going on with that. I mean, remember, this is in the wake of FDR's very highly publicized battles with the Supreme Court, and and one of the things that Michael Waldman's new book, The Supermajority, explains in details so well is the kind of public reaction to the Supreme Court at various times in our history, including at this time with the opinions of the 1930s and FDR's battle. So there was a lot of interest in the court because of that, but also there was a lot of interest because a lot of the Roosevelt administration war policies were in front of the court. Korematsu. The one thing we haven't talked about, the court upheld the very broad authority for price controls and rationing, giving the government a great deal of authority to deal with novel problems and complex crises. But these were all the kinds of things that the previous court had been striking down. And so there was very, very great interest in terms of the, kind of press coverage and public reactions, and even editorial cartoons about the court and the justices. And, I include a couple in the book, but there was definitely very great public interest in what the court was doing.
I guess one question, which I think is something that all of us struggle with a little bit, is, can the Supreme Court ever be apolitical or non-political?
Well, I very strongly think that, to understand the Supreme Court, you have to understand the environment that it's embedded in. It's very much a part of the dynamic with the other branches. It's very much a part of what's happening in DC and the country as a whole. As mentioned in my other book about Marbury versus Madison, that very much is a story of power in DC in the early 1800s. So to understand the court and the justices, you absolutely really have to understand them as part of their times, what they're experiencing, what they're reacting to. Now, at the same time, I don't think it's just a simple, one-dimensional equation of it. And the fact that different FDR justices came out differently on different issues sort of underscores that. So it's not that you can just, in a very simple and automatic way, predict exactly what they're going to do on every issue as a result of their being part of the times and as a result of their backgrounds. But it absolutely is not the case that they're sort of off in an ivory tower removed from it. I mean, we sometimes look at Supreme Court cases and precedents, and we, look at the four corners of the decision, and it's as though it's just a sort of freestanding decision, sort of, without any kind of a broader context. And I very strongly think to understand the court and its decisions, you have to understand the times and the context.
Yeah, and I think that's something your book is really effective as doing. It really made me see cases in a different light because of sort of explaining the political and social context around them. So I do think that is, in fact, very valuable. It gives you a better understanding. But one of the things, just to come back to the Roosevelt court slightly, though, when the court was striking down the New Deal legislation in the 1930s, right, it seemed to be very out of step with public opinion. And that's a criticism that's been levied on today's Supreme Court as well, that by striking down Roe versus Wade, for example, it's very much out of step with public opinion. And I think similarly in terms of sort of the ways in which it's been sort of curtailing the authority of the administrative state, of agencies like the EPA, et cetera, that seems to be sort of a retrenchment that has long been sought by certain parts of this country, but seems very out of step with sort of modern American society and the challenges we face. So I guess the question is, like, would you characterize the Roosevelt court that way as well? I mean,
well, the other, I agree with, the issues that you raise about the areas in which the current court is very much out of step with public opinion and also with what I think is appropriate constitutional interpretation when, for example, it's stripping people of fundamental rights that they've had for 50 years and has, roots that go back, further than that. At the same time, and again, the history of the court, a lot of times there's a democratic counter reaction when the Supreme Court gets fundamentally out of step and these very worrisome decisions about choking government's ability to deal with novel problems and complex crises. At the same time, I do want to emphasize that I think there's a very important role for the Supreme Court sometimes in going against public opinion and protecting the rights of people who are reviled or despised, or, public opinions and passions have run against. And so, and Korematsu is a great example of that because, public opinion was very much in favor of this incarceration and persecution of American citizens of Japanese descent. And it's the job of the Supreme Court, a very, very important and essential function of the Supreme Court in situations like that, to kind of protect civil liberties, even when it's very unpopular to do so. And so I think there also is, and you see this with the war court, there can really be a danger when the court is too willing to sort of follow public opinion when it would lead to, the deprivation of rights for unpopular minorities.
Yeah, so how do you sort of thread that needle though, right? Because on the one hand, you want a court that sort of is kind of keeping up with the times, if you will, and what the American public broadly wants in terms of sort of lifting us all up. And at the same time, you want the court to be, protective of minority rights, of people who are at the margins of society. And sometimes it seems that those two philosophical goals often come into conflict.
Yeah, well, one thing that has been very influential in constitutional law is actually something that Harlan Fiske Stone wrote when he was an associate justice in the 1930s. And, for lawyers or law students, the famous footnote 4, the Caroline Products decision. But what he said was very, very important and a kind of a principle that was a guiding principle in the Supreme Court for many years, which is that on issues of economic activity and the regulation, the Supreme Court should be very deferential to the scope and authority of government. But on issues related to, he said, discrete and insular minorities and people who could be excluded from the political process, it should be active in protecting constitutional rights for those who would be excluded or despised or reviled and not allowed to participate fully. And as I mentioned, that was a very, very important guiding principle for the Supreme Court for many decades. Now, unfortunately, in my view, the current Supreme Court is doing almost precisely the opposite. Yeah. It is choking off government ability to deal with complex problems ranging from COVID to climate change and many others, in making up doctrines that hadn't been there before, like the so-called major questions doctrine. And at the same time, in terms of the threat to constitutional rights and civil liberties by minorities, by those who aren't able to fully participate in the political process. So it's almost the exact reverse of Caroline Products. But in my view, the Caroline Products footnote by Harlan Fiske Stone actually got it right on how to thread that needle that you're talking about.
Great. I think we have time for one more question. Let's see. What would be interesting? Okay, so here's a fun one. Can the DOJ indict a Supreme Court justice for corruption?
In my opinion, off the top of my head, I would say yes, absolutely. If a Supreme Court justice, was, let's put it this way. I mean, it's always helpful to imagine the most extreme situation in this sort of, blatant bribe or something like that, I think absolutely. And we've seen lower court judges actually who have been prosecuted and convicted. And I absolutely think that same position should apply to Supreme Court justices as well.
All right. Well, we're at the end of our time now. So I guess as a last question, Cliff, what do you want our audience to walk away with today?
So one point that I would hope that the audience takes away from this discussion is that the Supreme Court, in a series of opinions protecting and expanding constitutional rights on areas from reproductive rights to voting rights, did so as part of the existential fight for our constitutional democracy, and in explicit contrast to the fascists and the authoritarians and the Nazis that we were fighting. And those opinions, recognizing reproductive rights, recognizing voting rights, protecting the rights of persecuted and despised religious minorities, and also giving the government broad authority to deal with novel crises and complex problems. Those were very important foundations for the next 3/4 of a century. And they all are under fire by today's current Supreme Court. And in my opinion, to sort of borrow a phrase from Justice Robert Jackson during the war years, those principles should continue to be a guiding star in our constitutional constellation.
Well, Cliff, thanks so much for leaving us with those very inspiring words. Thanks for being with us today and for the insights you shared, both in this book and in the discussion. And thanks so much to all of our audience for your questions. I wish we had time to answer them all, but I think we got a good cross-section of them. If you want to stay up to date on more Brennan Center perspectives as cases that will have really profound effects on our democracy and system of justice are being considered in today's Supreme Court, you can sign up for our newsletters. You can sign up for the briefing newsletter at brennancenter.org/briefing. We also hope you'll join us for our next event in the Supreme Court, which is on October 12th. And it's called a Supreme Court Fact Check: The Supreme Court's Appeals to History Get It Wrong. Registration for the event will launch soon, so keep an eye out for that. I'm Faiza Patel, Senior Director of the Liberty and National Security Program at the Brennan Center. Thanks, everybody, for being here today.